Commonwealth versus Berrios.
Ms. Dillon.
Good morning, Your Honors. Diane Dillon, Assistant District Attorney representing the Commonwealth. This is the Commonwealth's appeal from the judge's allowance of a post-sentencing motion to withdraw guilty pleas to accessory before the fact to murder in the second degree.
I have a question. I'm sorry that I need to be certain of to understand the background. Is it clear from the record that the offer for a plea to second-degree murder would not have been available if the defendant went forward with his motion to suppress?
No, Your Honor. There's no basis on the record for that finding by the appeals court.
Okay. So there's no basis for that finding?
None whatsoever. In fact, the appeals court found that it happened on the day of trial, and that's what they found was so egregious as a bargaining chip. And indeed, the offer had been made before. Counsel had been conferring with the defendant all weekend long, conferring with the defendant's family. So there is no basis on the record for that finding.
No basis for the finding that if the defendant had gone forward and litigated his motion to suppress, the Commonwealth would have withdrawn the... No. And that's in the record?
There's nothing in the record to that effect whatsoever.
Okay.
There's no reason to believe that that is so.
Okay.
When the judge accepted the plea, he found that the plea was a voluntary plea. He advised the defendant that he would be giving up any right to appeal the motion to suppress that had been found, and he expressed some concern that he was seeing so many young people who were involved with gangs who ended up in this situation. And even when he heard the motion, he acknowledged that there was nothing in the contemporaneous record to indicate that this plea was anything but knowing and voluntary. The Commonwealth's two contentions are, once he made the finding that there was no ineffective assistance of counsel, he should not have gone any further, because a plea of guilty bars a defendant from raising any antecedent constitutional violations. There's nothing on the record to support the judge's finding that there was something unique about this plea. It was indeed a young man, but it was a young man who was the president of Los Salidos. And he admitted that when they saw these Latin kings across the street, there was a meeting in the bathroom, and this court has found in Francis, and Mr. Rodriguez and others have testified, the initial meeting in the bathroom, they agreed that something had to be done about those kids across the street. And then this defendant, as president of Los Salidos, left the bathroom, and the enforcer, according to their rules, is the one that took care of the actual planning, getting the gun and determining who would go do it. He's accused of, and he pleaded guilty to, accessory before the fact to murder, that he counseled and encouraged, as he admitted at the time he entered the plea, that he counseled and encouraged the murder of Carlos Falcone, is sufficient. The appeals court complicated matters by reversing the judge on the finding of ineffective assistance of counsel and making some findings on the record that are not supported by the record or which are contrary to prior holdings of this court. As you've already inquired, there is no basis for the finding that foregoing the motion to suppress would have been a prerequisite to pleading to murder too. That finding is just finds no support whatsoever in the record. More importantly, or one of the things that's important, is the appeals court said that the counsel should have litigated the motion to suppress so that the defendant could have had a better understanding of where the case stands. This court has never held that it's appropriate to second-guess a decision by counsel when there's evidence on the record that he had in fact investigated it. And as far as the viability of the motion to suppress, Attorney Bernard testified that based on the evidence the defendant had given him, the photographs that show that the injuries were photographed in a residential setting, the fact that he was never released after his arrest gives rise to some substantial questions about his credibility.
I had one question about the facts, and it's minor, but I don't understand what, on page 28, you talk about the defendant being familiar with an affidavit filed by Robert Schuler in support of a motion to suppress in Schuler's murder case. I just don't understand the connection. You don't make it clear in your brief what that is connected to.
Yes, Your Honor. The
I
defendant
couldn't follow.
had instructed his attorney to go to these various lawyers and look up the two motions to suppress, Carrasquillo and Schuler.
And they had both failed.
They had both failed, but the allegations in each of them, and I did submit certified copies of the affidavits, the allegations are almost identical.
Oh, okay, all right, then I follow, thank you.
And against the same officer, and they're complaining of the same conduct. The wording is almost identical, and both of them had failed. So he knows that those two things have failed. He has the photographs to question it. The medical records in the booking sheet don't support his other allegation of misconduct. So he knows that what the defendant is saying is going to raise some questions about his credibility. He says he didn't get Miranda, but we have copies of a signed Miranda warning. He says he couldn't make a phone call, but his family ends up there. So the attorney is looking at that, and he's saying, maybe this isn't really a viable motion. And he is obligated under the rules to advise his client that there are problems with this. And he did so advise his client, and his client spoke with him over the weekend. His client spoke with his family over the weekend. If you look at all of the facts, and you look at the fact that the two co-defendants who did go to trial were found guilty of murder in the first degree, the motion judge's finding, or the trial or plea judge's finding, that this was not ineffective has a good basis in the record. The appeals court finding that he was ineffective is flawed because the appeals court found that Mr. Rodriguez changed his testimony.
Do you read the motion, I'm sorry, do you read the motion judge's findings as saying that the defendant's plea was not knowing and intelligent, or that or did the motion judge's finding include a finding that the plea was not knowing, intelligent, or voluntary?
I think the judge's finding focused on the voluntariness, that he felt pressured because of the situation.
Even though the judge never used the word voluntariness in his findings?
No, his findings are very inchoate. He doesn't really say it. He just said that under these unique circumstances, but he never says what was so unique.
Yeah, it strikes me, however, reading it, and he was the trial judge, right?
The plea judge, yes.
Plea judge, I'm sorry. Was he the trial judge at any of the other trials?
No, I don't believe he was. Judge Moriarty heard the Francis case, and no, he didn't hear the Giles case.
Trying to understand the judge's ruling, it seems to me he's saying, on the one hand, that there's a real significant chance that not only is there a viable defense, but that this fellow's not guilty. And secondly, there's real pressure put on this person to plea, not only by his lawyer, maybe perhaps overemphasizing the strength of the Commonwealth's case, but also by his lawyer through the family to sort of urge him to plead guilty. Combining those two things, he thinks there's perhaps a miscarriage of justice here. Why isn't that enough?
Because this is a post-conviction motion to withdraw a guilty plea. And if you're going to let him do that, the defendant has to come forward with substantial and credible evidence in support of that.
Well, the judge found him to be credible in terms of his not wanting to plead guilty, his being sort of, in essence, forced to do it because he was told there are just no circumstances you can get around this.
The only finding of credibility is that he didn't want to plead guilty. But I would suggest to you, Your Honor, that if you look at Cepalonis and Hewitt and a few other cases, it's just inherent in the circumstances of this case. This young man is facing the fact that there is powerful evidence against him. And
actually not so powerful as it turns out, but
I beg to differ, Your Honor, and I would suggest to you that if you look at the fact that two co-defendants were found guilty of murder in the first degree, and that even if you didn't have his confession, you have all of the testimony of the other people who did testify in the other two cases.
Well, the only question was whether he was in the bathroom at the time that this discussion took place. There was certainly testimony. There were a lot of people in the room. The real question was he in the bathroom? And it doesn't strike me that the evidence was very powerful on that subject.
Well, there was a statement from Rodriguez that he was in the bathroom at least part of the time, and at least at the time when
the decision was made
to kill two of the kings.
No, I'm not saying the evidence was insufficient. I'm saying it's hardly an overwhelming case.
I'm just suggesting to you, Your Honor, that two jurors who heard the same evidence, even absent a confession,
but he heard the same evidence, but not about him. Heard the same evidence about others who were, in fact, in the room.
that he was in the bathroom when the plan was made. And then after Jason Giles went out and came back and said, yes, I'm sure that they're kings, he encouraged them.
Focusing on the plea judges, what concerned me, he goes through a quite long description of what the evidence is, or what the counsel thought the evidence was, and then focuses on the fact that the family came and said, you really should take this plea.
You should.
I can imagine that for many family members, if there's a risk, and whether, one says it's an overwhelming risk or a substantial risk, but there's not whether it was powerful evidence. This wasn't, a no-brainer. This was a pretty powerful, substantial evidence that he might be convicted of murder in the first degree. It strikes me as not unusual that family members would often come and say, look, you can't roll the dice here. It's a safer, better, you're more in control. Who knows what will happen? It's not for life. You will have the possibility of parole. That strikes me as not entirely unusual, and yet the judge seems to place enormous emphasis on that.
I agree. It's not unusual. In fact, I would suggest that we oftentimes encourage defendants to seek counsel and advice from relatives, and that he got realistic advice from his family.
What were the unique circumstances? The judge says that there are unique circumstances here, but he never identifies, to my mind anyway, what's so unique about. It seems to me that these are very typical circumstances. Your counsel advises you to plead after making a reasonable assessment of the evidence, and your family begs you to plead because they want to see you at some point rather than never.
That's exactly it, and that's why I emphasize what the judge said at the time he accepted the plea and found that it was voluntary. He said, I see this all too often, young men who get involved in this just in the name of gangs. Unfortunately,
I think we have to go into this assuming, I don't know why you're so focused on the actual plea colloquy. Of course, if the judge said at the plea colloquy, gosh, I don't think you're doing this voluntarily, but I'm going to accept it anyway, then, of course, it would be an issue. The plea colloquy, of course, is straightforward.
Yes,
the issue is whether there's something behind the plea colloquy that this judge, after hearing evidence, determines created a circumstance where this person's will was overcome in some way, in a case where perhaps the judge thinks the evidence isn't so strong, as it turns out.
Well, he said there are unique circumstances. He never defined the unique circumstances.
So should we send it back for further findings on that subject?
I don't think that that would be fruitful, because the law is, or has been, that if the defendant seeks to go beyond the record to show unique circumstances, it's his burden. And he did not show unique circumstances. He did not show that he had a motion to suppress that would have succeeded, as Comita says he must. The very fact that he just had a viable one is not legally sufficient. Comita says that he has the burden of showing that he would have succeeded. The appeals court...
And the judge never makes a finding that the defendant made a showing that he would have succeeded.
No, he did not. And the law requires that he make such a showing. The appeals court faulted the Commonwealth for not coming forward with evidence that we would be prejudiced. Previously, the law in the Commonwealth has been that it is presumed in DeMarco that if a plea is accepted and it's later withdrawn, and in DeMarco it's only 1 week, it's presumed, it's intrinsic, there'll be problems. Now we're going back, 12 years? The very fact that the witnesses are incarcerated...
Excuse me, I'm sorry. Within months of this plea, however, there was clearly an indication that this person wanted to withdraw his plea.
Yes.
Okay, so we're not talking about a motion filed 12 years later.
No.
You're talking about prejudice now.
Yes.
And should the defendant be held accountable for the fact that this took so many years to work its way up through the system?
Nor should the Commonwealth.
Ms. Denon, could I just I haven't had a chance to look at the record, and if you can't remember, that's fine. But in your brief, you said the judge found that the record of the plea transcript did not indicate that the defendant was coerced into pleading guilty. So that's based on the record of the plea transcript, correct?
Yes.
Would it be fair to say that there is implicit in his unique circumstances a finding that the defendant had been coerced
No, the judge specifically says, I find there was no coercion.
No coercion.
It's right in his findings.
It is just too inchoate to allow this defendant, the president of the Los Alitos, to withdraw his plea. There is not one reason set forth on the record for this other than, I think, a very human attitude on the part of the judge. Here's a young man who's going to spend a lot of time in jail. But there is no legally sufficient reason for the ruling, and the rulings of the appeals court do not find a basis in the law or in the record. Thank you.
Good morning, Your Honors. Joe Krosky for Mr. Berrios, and with me is Mr. Howard, and Mr. Berrios and his family are in the courtroom as well this morning. To answer the question on whether or not there would be a deal as withdrawn if there was an effort to go forward on the motion to suppress, I would suggest to this Court that the counsel was totally unprepared to go forward with a motion to suppress, had really no idea how to even litigate a motion to suppress, and in the day that he showed up for the motion to suppress, he intimidated and coerced Mr. Berrios into accepting a plea on second-degree murder. There was only minimal, according to the record and the testimony, only minimal conversation between Mr. Bernard, the trial counsel, who had only been out about 4 years at that time, and Mr. Safford from the district attorney's office.
Mr. Krosky, the law is, as you're aware, that on a motion for new trial, it requires that if there's a motion to suppress which the attorney failed to litigate, it must be shown that there was a reasonable likelihood of success on the merits. Now here, there's a finding that before you can have a reasonable finding of success, you have photographs of the defendant's bruises that were taken in a residential setting when he was never, let me finish the question, when he was never released between the time supposedly of the brutality and ever afterwards. So how would he be, what would the photographs be worth? They would be, it would be indicative that the defendant's credibility is not worth very much. Then you have two co-defendants who had already lost on very similar motions to suppress. And then you have his own inconsistencies between whether he signed a Miranda, there's a document that he signed Miranda warnings and he's saying he didn't. You have his mother and his girlfriend's testimony, which is suspect on its face because bias is inherent, but also their testimony, as I read it, was mostly that his face was swollen from crying. He had been crying. They said his eyes were red and his face was swollen. That doesn't indicate police brutality. So how did the defendant show, which is his burden on a motion for a new trial, that his motion to suppress had a likelihood of succeeding? And the judge never found it did either.
I understand. There's some confusion. Mr. Berrios, with the same officer, had been involved in another motion to suppress prior to his arrest on this offense, and I think there was some confusion of those pictures. He had won a prior motion to suppress when a gun was taken from his knapsack, and he did have a prior run-in.
Is there evidence in the record that the photographs were from the prior arrest?
I'm confused myself as to how those photographs went in. I know today, in reviewing all of the testimony,
well, they didn't go in on this case. It's just as I read it that the defendant gave them to his attorney. They never went in because
and I'm not sure because Mr. Bernard was involved in this case. I think in the post-plea portion, within a week or so after there was a plea, the plea went down with Mr. Berrios, who contacted Mr. Bernard by letter and saying, "What about the statement against me?" And the pictures, there was a whole lot of confusion. There was another motion to suppress, but in this particular case, the motion to suppress basically was on Mr. Berrios being held for 2 days without food, without water, and the psychological coercion. Now, that was never fleshed out by Mr. Bernard. There was a motion
Did
filed.
You argue, was this ever argued to the motion judge that it was psychological coercion?
Oh, yes.
Motion to suppress, not physical beating?
Oh, there was a physical beating as well. But basically, it was the deprivation from family, from food, from sleep, and that was part of the testimony of Mr. Berrios' mother and his girlfriend. When they were called down to the station, Friday, Saturday, and Sunday, they weren't allowed to go in to see him, and during this entire time, Lieutenant Kelly, who at that time, and I was able to get a dossier of prior cases in which Lieutenant Kelly had been involved in the same kinds of things. That was his modus operandi. He would take a softball.
But the two motions to suppress involving similar allegations against Lieutenant Kelly had been denied.
One of those, I believe, was prosecuted for perjury. There was never a connection between Mr. Berrios really laid out. I didn't know about any of those until, I think, the fourth day of the motion.
But how would a finding be warranted that the motion to suppress would be likely to succeed in the face of, if nothing else, the two similar motions had failed?
Well, it goes to, this is a Chetwynd issue. The information given to Mr. Berrios by Mr. Bernard as to the viability. At one point,
it was good information.
It was not good information. First of all, he tells the judge that he thinks that maybe he would have done a humane practice, Tavares type of in limine motion during the course of the trial. Well, you can't, if you think you have that, you have an obligation as a defense counsel to file a motion to suppress to at least see what the testimony is going to be like. It's absolutely ineffective to just rely on a Tavares or a humane practice voir dire during the course of trial.
There's no finding by the judge about anything about a humane practice instruction.
I understand that. My belief is that the judge was splitting the baby because the appeals court on the record saw what went in through the testimony on the record through Mr. Bernard. Now, one of the reasons that Mr. Bernard was so evasive was he said...
You have not presented anything to indicate why this motion to suppress would have succeeded. Why it was unreasonable.
Well, we don't know that any motion will ever succeed,
but
we have a duty
it's the defendant's burden to present evidence to the motion to withdraw judge that the motion was likely to succeed, had a reasonable chance of succeeding.
I suggest that the judge found that Mr. Berrios, the hearing judge, the plea judge, found Mr. Berrios to be credible.
He found him only to be credible in his assertion that he did not want to plead guilty to the indictments. He did not find him to be credible in general.
Had he testified in his own behalf, and Mr. Bernard said he was a credible young man, he was an articulate young man, and that if he had testified on his own behalf, and this is what he had told Mr. Berrios, and Mr. Berrios testified, that there was a chance that he would be believed that he was held incommunicado for 2 days, deprived of sleep and food, and physically abused by Lieutenant Kelly.
But the same, you keep repeating, but that type of testimony didn't succeed in the prior motions to suppress.
That was not Mr. Berrios' motion. Those were different facts. It wasn't even related to this case. Those two motions that Ms. Dillon is talking about were not part of this case. They were unrelated cases that happened someplace else, of which I have no knowledge. I know there was some fellow named Sherma whose some documents were given to me in the fourth day of the hearing. They had nothing to do with the State Street Kentucky Fried Chicken case. So as far as them being applicable to this case, they are inapposite, Your Honor. They did not have anything to do with this case, had no bearing on this case. Mr. Berrios' motion to suppress stood on its own feet, stood on its own terms. And he would have come into court and been able to testify, as he did on the motion for new trial, that I was held from Friday afternoon around 4 o'clock till Monday morning. I didn't have any food, I didn't have any sleep, and I was kept up and I was interrogated. My will was broken down. They wouldn't let my family in to see me, and I was pushed around by Lieutenant Kelly. One of the things that he would do, which he was known for, is take a softball and throw it off the wall in the interrogation room. Not hitting people with it, but that kind of psychological anticipation of this thing happening.
But we don't have any finding by the motion judge that the motion would have been successful, had a likelihood of being successful.
Well, he found Mr. Berrios credible. I don't know.
We go round and round. He found him credible in his assertion that he did not want to plead guilty to the indictments. That's the only finding on credibility.
Please do not listen to this testimony about other motions to suppress that weren't successful. They had nothing to do with this case. Mr. Bernard was totally unprepared to try the case. In fact, talk about credibility. Mr. Bernard, and this was the testimony, filed a motion in November or October to continue the case of Mr. Berrios because he was feeling, or he had a family medical emergency, and he was somebody was confined to home, himself or somebody else, with this unknown medical emergency. Come to find out, during that period of time, Mr. Bernard, trial counsel, was running for school committee in the city of Springfield, and he gave an interview with the Springfield Republican when he won that school committee seat that he attributed it to hard work, working 60 hours a week. Here's this credible attorney now who says in an affidavit signed under the pains and penalties of perjury, he can't come in and try this case because he's got a family medical emergency, and then after it's over...
The two things aren't inconsistent, aren't necessarily inconsistent.
You can't, through
He
November...
might have had a family medical emergency right
Well,
then.
that's why he couldn't... Then he says that he was working 60 hours a week on his campaign for school committee. That's disingenuous, I suggest. He took money from the family to fire an investigator, never investigated, never sat through Mr. Giles' trial, in which it was clear. Now, there were two bathroom conversations. One conference was about Mr. Berrios being kicked out of the Salitos, had nothing to do with setting it up. Then this fellow, Concepcion, comes in, and the other fellow saying, hey, there are kings. Now, you have to remember, these kids are just wannabes. This isn't anything to do with guys with prison tats all over them and the tons of kilo coming in. Matt Brown was the only guy that had anything to do with drugs in this whole group, and he's just selling nickel bags out of his pocket. These are kids...
It's a little hard to characterize these kids.
They had guns. I understand. They had guns.
They're
and
criminals. They're criminals, is what they are.
Well, they turned out
now,
as this case...
Maybe this man was pressured into pleading guilty. Maybe.
He was pressured.
But these people are bad people.
I don't disagree that the two Giles brothers were cold-blooded. Concepcion was cold-blooded. Mac Brown, who got a second degree after a plea, one of the shooters, they were bad people. This fellow was being kicked out of Los Salitos because he didn't want to participate in the violence anymore. And the president, according to this hierarchy, had no powers when there was any kind of confrontation on the street.
And he was the president, your fellow.
But the president, according to this hierarchy, this chain of command...
The president had no authority in time of war, right?
Right.
Okay, and your client testifies that Los Salitos had nothing to do with violence. Well, what is war if not violence?
He had not. That's why he was being kicked out.
But he was the president, and so for some period of time he was the president, and there was a warlord who took over in time of war, and yet your client says that Los Salitos had nothing to do with violence. I find that pretty
No, not Los
inconsistent.
Salitos, himself.
But he was the president.
No, he was not president. As a matter of fact,
He was president at one time.
At one time, but at the time of this bathroom meeting,
I understand,
he was suspended from the
I'm on
presidency.
another point. I'm saying that he was the president of a group that had a warlord who by their organizational chart was empowered to act in times of war. He was the president at some point.
Not at this time, not in February of 1995.
I understand that, but he's the president of an organization that engages in war at some point because it has a warlord and it gives him authority in times of war. So how can your client be considered credible when he says that the Los Salitos has nothing to do with violence?
No, not Los Salitos himself. It was about himself.
He's the president.
He was not president at the time. It was quite clear. He was suspended for this belief that that we shouldn't be doing this. We should be helping the community. He would.
That he was some kind of an altercation or dispute with Concepcion. That's the theory behind Concepcion bias and all of that. That it had to do not with any refusal to participate in violence or worse violence, but for engaging in violence against one of Los Salitos' own members.
There were two problems facing Mr. Berrios. First of all, his attitude about what this group was doing. He was on his way out, and he was having problems with Concepcion. And it's quite clear, Concepcion was the little weasel who came in and started this whole thing. He was so bad that the district attorney's office wrote all of those letters in which he admitted turning on Mr. Berrios to protect his friend Jason Giles. Those letters were read to the grand jury.
If Mr. Berrios is on his way out and he doesn't want anything to do with all this, why did he stay in the apartment during the whole thing after he left the bathroom? He didn't leave the apartment. He stayed there with all his Confederates.
And the key was what happened in that bathroom.
No, you're not answering my question. You said he doesn't want anything to do with this. Then why does he stay there with his 5 or 6 friends?
I think it's clear that at this point he doesn't know how bad it's going to be because he's not part of that conversation that's going on in the bathroom. Daniel Rodriguez made it clear under oath in the testimony of the Jason Giles case that Mr. Berrios was out of hearing range. He was excluded. Yeah.
What I think Concepcion's, is his letter, I guess, right?
Right, to Jason Giles.
What it is confessing, what Concepcion is confessing to is, I'm lying when I exonerate Jason Giles. You know, I am, my lie was, you know, I'm going to protect Jason Giles, even though I know he's guilty. And then going, but I'm not going to protect Berrios because I think he's a snitch. Now, that's not a statement of I'm pinning it on Berrios instead of Giles. Wasn't Giles one of the shooters?
David Giles.
Shooter.
Okay.
Not Jason Giles.
Not Jason, I'm sorry. But
There were two Gileses, that's why it's referred to as David and Jason.
it seems to me you are reading into what Concepcion's letter means and how it could be used as impeachment. Something that the letter does not
What?
contain. The letter does not say, in word or substance, that he was falsely accusing Berrios. It was, I'm willing to lie to protect Jason Giles. I am not going to lie and protect Berrios because I think he's a snitch.
I think that they neutralized and took any defense potential out of Concepcion, the district attorney's office, by putting those letters into evidence in the grand jury. That meant he was tainted for everybody. And it's not how viable those letters were. It is what use Mr. Bernard not only put to them, but he didn't even know about those letters for impeachment value. Mr. Bernard, and this is the crux of the thing, Mr. Bernard knew nothing of the letters, knew nothing of Mr. Rodriguez's testimony. But he was totally unaware, or he hid it from Mr. Berrios. When he's talking about Mr. Concepcion's testimony being devastating, it was anything but devastating. It was the most vulnerable cross-examination testimony I, as an experienced trial lawyer, has seen. So Mr. Bernard lied to Mr. Berrios when he said Mr. Concepcion's testimony is devastating. His testimony, Mr. Concepcion's, was impeached by the district attorney's office itself.
Mr. Krauske, though, it's my understanding, and correct me if I'm wrong, that the Commonwealth produced in discovery copies of letters written by Concepcion to the co-defendants, and that's in the
Yes.
record appendix.
I'm talking about, this is all about Mr. Bernard's conduct here.
Right, but so that the Commonwealth produced in discovery, so he had these letters from Concepcion,
Who did?
the defense attorney, Bernard.
But he misrepresented those letters to Mr. Berrios, and I don't even think that he showed Mr. If you look at the
Berrios
testimony,
admitted that he had seen the letters.
Mr. Bernard wasn't aware of any of the witnesses, didn't know who Charlene Alvarez was, had never been to the apartment, didn't know who Daniel Rodriguez was, the key witness who said Mr. Berrios did not participate in any conversation. Mr. Bernard, the so-called defense lawyer, did not know who the key witness was who would have exonerated his own client, and he lied to Mr. Berrios about it.
Sorry, Berrios acknowledged that his attorney had shown him the letters. That's in the transcript of the hearing.
But the legal strength of those had to be communicated. If those letters were in my possession and I had to discuss those with a client, I'd say, look, we can kick the baloney out of this guy with these letters. Instead, Mr. Bernard takes letters to any trial attorney, knows would have been valuable impeachment material, says this testimony is going to be devastating. The district attorney's office didn't even believe that Mr. Concepcion's testimony was any good. And as far as the motion to suppress...
What makes you say that? I wonder that. You kept saying that. Why do you say that the district attorney's office believed Concepcion's testimony? You say that in your brief.
Because they had a police officer read all of those letters in before the grand jury.
That doesn't mean that.
That means that if Mr. Giles's attorney calls Mr. Concepcion as a defense witness and he gets on the stand to testify for Mr. Giles, the district attorney now has on the record, under oath, strike that, on the record, those letters that Mr. Concepcion wrote to Mr. Giles. So it devastates the case against Mr. Giles, those letters. So they have disemboweled and eviscerated and neutralized Mr. Concepcion's testimony for defense purposes. So the district attorney knows that Concepcion is not credible. And Mr. Bernard should have known that. He never should have said the testimony is devastating. If I saw those letters, I'd say this case is over, because if they put Concepcion on the stand, I'm going to cut his legs off piece by piece with a razor blade.
Mr. Klowski, I know you've been answering Justice Cowan's questions, but your time is up.
Thank you, Your Honor.
So we'll take a break.